Hi, everybody. Good afternoon. How y'all doing this afternoon? I'm good. I came back because yesterday I saw a trailer for it appears to be a series that's going to cover the Idaho Four murders. And I'm not sure if there was a timing issue with that because the trial is not starting October 2nd. It's been indefinitely postponed because they need more time, because they're still investigating, they're still reviewing evidence, gathering their expert witnesses, preparing their witnesses. So I think what is happening now, because the anticipated trial has now been pushed back, there is anticipation to release maybe a docu-series or maybe movies about what has happened to the four victims and what's been going on forensically in the case, some of the evidence, a lot of witnesses. There's so much information about the case out on these social networks, and there's been a lot of interest, right? So I think when the case was not going to move forward and start a trial October 2nd, it became apparent to some of the companies that they were not going to wait and they were going to release whatever series or movies or whatever is going on. Um, now, now, typically, you do not see this because this could affect the trial, right? Whenever, whenever you have a high profile case, in this case, it's going to be high profile because it is a large crime scene. The crime scene is a 3-story house. You have multiple victims, so that's going to take a lot of work on the police, law enforcement, and investigation side to uncover what happened and why, right? You have multiple victims. You have the issue of how do you catch the criminal or criminals, right? So what has happened in this case, the potential of gathering evidence has really expanded. By this being in close proximity to the university and also being in an area where there's a lot of college students, there's a lot of people impacted. Not only do you have the university that's impacted, you also have the adjacent community. And the adjacent community in this case is, if you want to say, a college town, a college community, primarily made up of college students, youthful, young students. The idea of gathering evidence is going to be enhanced because you have so many people involved. Even with their arrested suspect, the amount of evidence, amount of collection of that evidence, the voluminous task of reviewing it, from interviewing witnesses, taking on tips and leads, and filtering through those to see which ones have value to follow up on, to people that may come forward with information that may not be true, may not be related. You have to filter all of that out. Then you're going to have a mirror that reflects back to the community. So the community is going to look for instances where they feel something was not right. So you may have people that call in, for example, they were trying to relate an incident about a dog to what happened in this case. There's been talk of other unsolved cases and murders that could relate, could be similar. You can talk about the instances where some of the interactions with police have come up. Just a sheer amount of things that the police have to investigate, the people they have to investigate, witnesses that they have to talk to, the collection of evidence, the idea that a lot of what will be reviewed is video related. So these could be videos that the police gathered. These could be videos that people called the police and provided. These could be traffic stops from law enforcement. These could be cameras that pick up cars for maybe even ticketing, right? You could have cameras in the community on campus at the university. You could have a camera system that shows you different areas of campus. It's so much to review in this case. What makes it challenging, I believe, that there is some expectation by the community, by some involved, and that could include the victim's family members, that the information that is collected, that has been reviewed, that's being processed, that may go to the lab or may have to be interpreted by an expert witness, for example. I believe that there is an expectation that those results will be reported in some meaningful way back either to the community, to people involved, or to the families. However, that is not how investigations work. Criminal investigation, you want to protect the evidence. You want to preserve the evidence. You want to maintain the integrity of the investigation. And that kind of equates to not leaking information, not discussing who may be a potential witness and what they know. That may be not detailing aspects of the investigation, including who could be a witness, who is a potential suspect, evidence that's being collected, or even simple details about the time of the crime and other things related to the crime scene. What is happening now, I believe, I think there is a rush to want to know the why. Pretty much the how has already been out there. Now that doesn't make it true because it's out there, but it's out there. We can't do anything about that. So that is another thing that we're going to have to contend with. Even though I'm trying to turn my phone off. There we go. Because I don't want to be uninterrupted. I want to be able to focus very closely on why I'm saying what I'm saying. So earlier this morning, I did a video. The video was about a victim. Her name was Maurice Ann Chevrolet. She was a 9-year-old who had been abducted, bound, gagged, assaulted, and strangled. She was unalive. The reason I brought the video forward, it was to educate everyone, including myself, on what is kind of existing and happening in the Idaho Four case, which is there was technology used. There was some DNA on her clothing. And that DNA, and this case was from 1964. Maurice was unalive in 1964. So we're looking at over 50 years. But they were able to obtain DNA from her clothing. They were not able to match the DNA, even though they had a known sample from the suspect. So what happened, a student came forward with interest and he wanted to use his skill set in liking to do genealogy, family trees. He wanted to use that to help law enforcement with this case that was out of the state of Pennsylvania. And he took about 18 months by building about 50 family trees, and he uncovered the suspect. Now, the suspect was deceased, but they were able to exhume the suspect's body, get a DNA sample, and match the DNA to the known sample of Maurice Ann's killer. So the reason I brought forth the case is because I wanted to demonstrate how building a family tree with the assistance of law enforcement, doing it the right way, doing the genealogy workup. And at that time, it took about 18 months. Over 50 family trees were built, and thus they were able to find Maurice killer. And her family was able to receive some justice, although delayed, right? And I related it to the Idaho Four murders because this case involves one piece of evidence that allegedly had touch DNA, and that was on a knife sheath that allegedly was found on the 3rd floor in the bedroom where the two best friends were. So again, this video is to focus on how potential witnesses are to handle being in a situation where they're anticipating testifying in court for, in this case, a criminal proceeding. Typically, witnesses do not provide interviews. They do not answer questions from the public, from the media, from the news, from investigators. And technically, witnesses typically work with law enforcement. So that means that when they're identified, they're going to give a statement, they're going to give an account. If a suspect is found and there are charges brought and that suspect is arrested, that witness may be asked to testify in court. The witness will work with the prosecution and they will prepare for that trial. There is a trial. And that witness is expected to uphold what they said, which was truthful. That should have been truthful statements. And this testimony, this questioning that's going to happen will be at trial, or possibly if there's a grand jury indictment or a preliminary hearing. It could happen in either of those instances, but these are all related to court proceedings. This is not going into the public. This is not making a public statement. This is not answering questions in a public platform. This is all relating to court procedure, whether it be a grand jury, whether it be a preliminary hearing, or whether it be trial. Okay, so after establishing that foundation, what is happening in the Idaho Four case? There has been a lot of leaks. There has been a lot of information that should not be revealed prior to trial. Some information, basic things that you can speak of in generalities, you can always talk about the victim in a general sense, how they were as a person, some of the things they enjoyed in life, if they were working, if they had interests, if they were going to school, if they had obtained a degree, if they had any kids. You can always talk in general terms about them as a person. And I believe you can make general statements like, you want justice. You are seeking justice. You want the public to provide tips. If you can come forward, maybe there will be a press conference and the family is there with the police, with law enforcement, and they're encouraging, if a child is abducted, for example, they're encouraging the abductor to release the child, for example. If they're trying to get tips to find a suspect, those are all things that pretty much are acceptable and normal. What is happening in the Idaho Four case, there has been many instances now, and I have not addressed any of them because honestly, I thought that things were eventually addressed privately to certain people that were releasing details of the crime, the investigation to the public. This leakage, it can cause some issues. The first issue that it causes for if you detail all of the things that you are aware of that has happened in a case and you release that information publicly, it makes it very hard for law enforcement. It makes it challenging because when they are interviewing potential suspects, when they're seeking a suspect, when they're going through those tips, when people are saying, oh, you should look at this person or look at that person, or if a person even comes in and says, I am the killer, right? How do you vet that? How do you question? How do you interrogate? How do you investigate that if most of the known facts, the evidence, what has happened, the scene, witnesses, if all of that is already revealed, a person can just regurgitate known information that has already been released in the public and social media. So they may know a lot of details, and these details can relate to only maybe what the killer, law enforcement, the victims, or any witnesses may know. So if you're giving out specific details that possibly only a few people, a limited number of people would know. How do you separate an investigative case if the leaks are out there for the known case fact? It makes it very challenging for law enforcement. Also, it's as if you're trying the facts, detailing the facts of the case in a way where you're not in court. Testimony, facts, putting on witnesses, talking about the investigation, describing the scene, talking about witness testimony, things like that. That's where you go to court and you see that at trial. You don't do that prior to trial or during the trial. In fact, when that happens, it is typically known as trying to render or obtain or mold a opinion before the trial. And a lot of people refer to that as tainting a jury because you're releasing details to put the details forward before the case is prosecuted in a court of law. So you're already putting details out there that a potential jury would read about, see, hear about, watch, and that's not good. Now, in this case, when things initially came out, I was concerned, and I said it before in a video a few months ago. Just very generally, you don't want to do that. But now I have to really look at this as a concern that maybe for some people, they may not be in line with the law enforcement and with the prosecutor's office. Maybe they feel that the way things are being handled, they are not being handled properly, allegedly. Because why would there be a continuous effort to continue to release specific details about the crime, the murder scene, the victims? Why would this continually happen? It's almost been 1 year. In the beginning, I gave a lot of grace because I have understanding of grief, the idea, and strong interest in wanting to find the assailant or assailants. So initially, there was a lot of grace given. However, I still have a clear understanding that the behavior is not appropriate. It can affect the investigation in a negative way. Fast forward, that was November of 2022. Now we have fast forward, we're in a new year. We're getting close to a 1 year anniversary. And the new details that again are coming out, it should not be happening at all. I don't understand if the goal, look at my background. Let's take a minute and look at the faces of Ethan, Xana, Kaylee, and Maddie. The goal has always been to find out, to hunt them, him, or her down who committed this heinous, words are not adequate to describe what happened to these four young adults. My effort, my focus has been these four victims from the beginning. The goal has always been to locate, to determine, to uncover, to solve their murders. And I do not have all the answers. I am, just like many other people, are trying to bring forth through investigating, through reading, through reviewing, through having some experience, some skill set to try to help law enforcement get to the goal. I put their faces in my videos because I want the focus to always remain on them. A lot of people are working hard trying to figure this case out. And the proper way to do that is to base our techniques on the requirements, and that is to follow proper procedure and protocol. And that's what I'm here to talk about today. I talked a little bit about it, and I was not needing to do this video. When I talked about the Maurice Ann Chiavelli case earlier, it became apparent to me that thinking that this was going to somehow go away these issues of the leakage of the case information, I felt that law enforcement or the prosecutor has stepped in and maybe discussed the procedures, how witnesses should behave, how they should not talk to the media, not release case details, evidence, information, witness knowledge, things like that. And I'm trying to weigh that with the needs of a grieving community, family members, parents, siblings. I know that is hard. I have been there. I have been a grieving family member. I want to convey that this behavior is not helping the case. It's not helping law enforcement. It's not getting us closer to finding the killer or killers of these beautiful kids, your kids. People in your community. It is not. It is a deterrence. And I want to give some information on things that relate to this. And it's all about witnesses, witness testimony. What should be happening when witnesses go to trial? How do they prepare for trial? And overall, how witnesses don't recommend that they discuss the case. So let's get started, okay? And I apologize if that introduction was long, but I just want to be clear on what the focus is for me and for most of the people that are doing the work. It is to find and have that killer or killers prosecuted for these heinous crimes. Okay? So I want to, on the Hidden Horror Facebook page, this is always where you can go. You can get information about the cases. You can read what I'm referring to in these videos. I'm going straight to this page and reading this information. Is for you, is for your building of criminal law. Okay? So first, we're going to go over some terms. We have 3 terms today. The first term is the word tampering. Tampering is the act or an instance of engaging in improper or underhanded dealings, especially in an attempt to influence. Tampering with a witness or jury is a criminal offense. See obstruction of justice, embrassery. So we're going to do embrassery first. Embrassery is the attempt to corrupt or instruct a jury to reach a particular conclusion by means other than presenting evidence or argument in court, as by bribing or threatening jurors, a corrupt or wrongful attempt to influence a juror's vote on a verdict. Also termed jury tampering, laboring a jury, jury fixing, jury packing. The word embrassery has tended to disappear. It is included in some of the codes, but the tendency has been to divide this common law offense into 2 parts, placing that which is appropriate thereto in sections on bribery and the remainder in provisions dealing with obstruction of justice. So our last term is obstruction of justice. Obstruction of justice is the interference with the orderly administration of law and justice, as by giving false information to or withholding evidence from a police officer or prosecutor, or by harming or intimidating a witness or juror. Obstruction of justice is a crime in most jurisdictions. Also termed obstructing justice, obstructing public justice. The goal is to prescribe every willful act of corruption, intimidation, or force which tends in any way to distort or impede the administration of law, either civil or criminal. It has been very largely attained partly by aid of legislation. and any punishable misdeeds of such a nature which is not recognized as a distinct crime is usually called obstruction of justice or obstructing justice, a common law misdemeanor. So, in this instance, as I'm talking, I am not alleging that there was any tampering, that there was any embracery, or that there was any obstruction of justice. What I'm giving you is some legal terms that they do not specifically apply to what is going on in this case. But, and however, if certain behaviors continue, this may be an issue later on with the leakage of the case details, crime scene details, referring to the witnesses and what they know. There has been a lot of leakage in this case. Okay, so let's get started. The first thing that I want to talk about, and it comes from justice.gov, and it talks about steps in the federal criminal process for discovery. I want you guys to know the criminal procedures, how things happen in a case. So we're going to start with that as a foundation. So let's start. Before a prosecutor begins a trial, there is much work to be done. The prosecutor has to become familiar with the facts of the crime, talk to the witnesses, study the evidence, anticipate problems that could arise during trial, and develop a trial strategy. The prosecutor may even practice certain statements they will say during trial. Meanwhile, the defense attorney is preparing in the same way. One of the first steps in preparing for trial is talking to witnesses who could be called to testify in court. A witness is a person who saw or heard the crime take place or may have important information about the crime or the defendant. Both the defense and the prosecutor can call witnesses to testify or tell what they know about the situation. What the witness actually says in court is called testimony. In court, the witness is called to sit near the judge on the witness stand. In order to testify, witnesses must take an oath to agree or affirm to tell the truth. There are three types of witnesses. A lay witness. A lay witness is the most common type. A lay witness is a person who watched certain events and describes what they saw. An expert witness is a specialist, someone who's educated in a certain area. They testify with respect to their specialty area only. A character witness is someone who knew the victim, the defendant, or other people involved in the case. Character witnesses usually don't see the crime take place, but they can be very helpful in a case because they know the personality of the defendant or victim, or what type of person the defendant or victim was before the crime. Neighbors, friends, family, and clergy are often used as character witnesses. To avoid surprises at trial and to determine which of the witnesses to call to testify, the prosecutor talks to each witness to find out what they may say during trial. These conversations will help the prosecutor decide whom to call as a witness in court. Another important part of trial preparation is reading every report written about the case. Based on information in the reports and the information from witnesses, the prosecutor determines the facts of the case. Prosecutors must also provide the defendant copies of materials and evidence that the prosecution intends to use at trial. This process is called discovery and continues from the time the case begins to the time of trial. A prosecutor has a continuing obligation to provide the defendant documents and other information which may reflect upon the case. A failure of the prosecutor to do so can expose the prosecutor to fines, sanctions by the court. Further, the prosecutor is required to provide the defense with evidence that may hurt his case, called exculpatory evidence. This evidence could show the defendant's innocence. If the prosecution does not provide it to the defense, it may require a new trial. So I think that is a great explanation to describe what happens in discovery that's going to lead up to the trial. There is a lot of responsibilities. The prosecution and the defense are very busy. They're busy interviewing witnesses, reviewing reports, and and so much that they really don't have time for what is happening in the Idaho Four case. They do not have time to have this leakage of information, of details that is not known to the public. The details that are being released will really be known primarily by the killer or killers, and also victims, witnesses, and possibly law enforcement. So this is not good. Okay. So let's continue. The next thing that I want to review, I want to go more in detail, and now I'm going to refer to the U.S. Department of Justice. They have provided some tips on testifying, and this is coming out of the office in Alaska. They have put together some tips. So I want to go over this to help the potential witnesses. If they are not preparing for court, they're not preparing for trial, this will help them do that. Okay? So the first thing you want to do is refresh your memory. Before you testify, try to picture the scene, the objects, the area, the distances, and exactly what happened. This will assist you in recalling the facts more accurately when asked a question. If the question is about distances or time, and if your answer is only an estimate, be sure you say it is only an estimate. Beware of suggestions by attorneys as to distance or times when you do not recall the actual time or distance. Do not agree with their estimate unless you independently arrive at the same estimate. So, for example, maybe you cannot recall the exact time. So you can use a word like approximately or the word about. That gives you some room so that it's not precise, but you're giving an approximate or an about time. Okay? I hope that helps you. Speak in your own words is the second piece of advice. Don't try to memorize what you are going to say. Doing so will make your testimony sound pat and unconvincing. Instead, just be yourself. Prior to trial, go over in your mind those matters about which you will be questioned. Here's the next tip. Speak clearly. Present your testimony clearly, slowly, and loud enough so the juror furthest away can easily hear and understand everything you say. Although you are responding to the questions of a lawyer, remember that the questions are really for the jury's benefit. Additionally, smoking is not allowed. I'm not sure why that's there. So next, they have a tip about your appearance in court. So let's go with that. A neat appearance and proper dress in court are important. The trouble with an appearance that seems very casual or very dressy is it will distract the jury during the brief time you're on the stand and they won't concentrate on your testimony. The next tip, do not discuss the case. Jurors who are or will be sitting on the case in which you are a witness may be present in the same public areas you will be. For that reason, you must not discuss the case with anyone. Remember, too, jurors may have an opportunity to observe how you act outside of the courtroom. The next tip, be a responsible witness. When you are called into court for any reason, be serious. Avoid saying anything about the case until you are actually on the witness stand. Okay? Avoid saying anything about the case until you are actually on the witness stand. They're titling that to be a responsible witness. Being sworn in as a witness is the next tip. When you are called to testify, you will first be sworn in. When you take the oath, stand up straight, pay attention to the clerk, and say, I do clearly. The next tip, tell the truth. Most important of all, you are sworn to tell the truth. Tell it. Every true fact should be readily admitted. Do not stop to figure out whether your answer will help or hurt either side. Just answer the questions to the best of your memory. Next tip, do not exaggerate. Don't make overly broad statements you may have to correct. Be particularly careful in responding to a question that begins, wouldn't you agree that? The explanation should be in your own words. Do not allow an attorney to put words in your mouth. Next tip, listen carefully to avoid confusion. When a witness gives testimony, he or she is first asked some questions by the lawyer who called him or her to the stand. For you, this is an assistant U.S. attorney. The questions, the questions asked are for the purpose of direct examination. When you are questioned by the opposing attorney, it is called cross examination. This process is sometimes repeated several times in order to clearly address all aspects of the questions and answers. The basic purpose of direct examination is for you to tell the judge and jury what you know about the case. The basic purpose of cross examination is to raise doubts about the accuracy of your testimony. Don't get mad if you feel you are being doubted during the cross examination. The defense counsel is just doing their job. Next tip, do not lose your temper. A witness who is angry may exaggerate or appear to be less than objective or emotionally unstable. Keep your temper. Always be courteous, even if the lawyer questioning you appears discourteous. Don't appear to be a wise guy, or you will lose the respect of the judge and jury. Next tip, respond orally to the questions. Do not nod your head for a yes or no answer. Speak aloud so the court reporter or recording device can hear and record your answer. Next tip, think before you speak. Listen carefully to the questions you are asked. If you don't understand the question, have it repeated. Then give a thoughtful, considered answer. Do not give an answer without thinking. While answers should not be rushed, neither should there be any unnaturally long delay to a simple question if you know the answer. Explain your answer. Explain your answer if necessary. Give the answer in your own words, and if a question can't be truthfully answered with a yes or no, it's okay to explain your answer. Correct your mistakes. If your answer was not correctly stated, correct it immediately. If your answer was not clear, clarify it immediately. It is better to correct a mistake yourself than to have the attorney discover an error in your testimony. If you realize you have answered incorrectly, say, "May I correct something I said earlier?" Sometimes witnesses give inconsistent testimony. Something they said before doesn't agree with something they said later. If this happens to you, don't get flustered. Just explain honestly why you were mistaken. The jury, like the rest of us, understands people make honest mistakes. Next tip, do not volunteer information. Answer only the question asked of you. Excuse me. Do not volunteer information not actually asked for. Additionally, the judge and the jury are interested in the facts you have observed or personally know about. Therefore, don't give your conclusions and opinions and don't state what someone else told you unless you are specifically asked. Next tip, don't set yourself up for error. Unless certain, don't say that's all of the conversation or nothing else happened. Instead, say that's all I recall or that's all I remember happening. It may be after more thought or another question, you will remember something important. Next tip, objections by counsel. Stop speaking instantly when the judge interrupts you or when an attorney objects to a question. Wait for the judge to tell you to continue before answering any further. Next tip, be positive and confident. Give positive, definite answers when at all possible. Avoid saying, "I think," "I believe," or "in my opinion." If you can answer positively, if you do know, then say so. You can be positive about important things which you would naturally remember. If you are asked about little details which a person naturally would not remember, it is best just to say so if you don't remember. Don't make up an answer. Next tip, follow courtroom rules. When being questioned by defense counsel, don't look at the assistant U.S. attorney or at the judge for help in answering the question. If the question is improper, the assistant U.S. attorney will object. If a question is asked and there is no objection, answer it. Never substitute your ideas of what you believe the rules of evidence are. Last two tips. Talking to others about a case. Sometimes an attorney may ask this question: have you talked to anybody about this case? If you say no, the judge knows that doesn't seem right because the prosecutor usually tries to talk to a witness before he or she takes the stand, and many witnesses have previously talked to one or more police officers or federal law enforcement agents. It is perfectly proper for you to have talked with the prosecutor, police, or family members before you testify, and you should, of course, Respond truthfully to this question. Say very frankly you have talked with whomever you have talked with, the assisting attorney, the victim, other witnesses, relatives, and anyone else whom you have spoken with. The important thing is you tell the truth as clearly as possible. Last one, do not discuss your testimony. After a witness has testified in court, he or she should not tell other witnesses what was said during the testimony until after the case is completely over. Thus, do not ask other witnesses about their testimony and do not volunteer information about your own testimony. So it is very clear. They really don't want you to talk about anything related to the case unless it's in court. And when you're done testifying, they don't want you to tell any other witnesses, right? Okay. So I have one more, and it's short. It's on law.com, and it's covering leaks in an investigation. That is the one. When leaks occur in a criminal investigation, leaks in a criminal investigation present significant challenges to prosecutors and defense counsel. Most prosecutors and agents adhere faithfully to their confidentiality obligations, but when leaks happen, they may generate intense publicity, especially if a high-profile individual is involved. From the prosecutor's perspective, leaks may reveal the target's identity, which may lead to flight or tampering with witnesses or evidence. On the defense side, leaks can tarnish the reputation of an uncharged client and create a risk that the case will be decided in the press rather than in the courtroom. Okay, that's from law.com. So we have one more thing to talk about, and this is getting at the heart of the case. The article is coming from CBSnews.com. The article is dated September 14, 2023, and is titled Father of Kaylee Goncalves, one of four murdered University of Idaho students, says there is evidence his daughter fought back. Okay. So let me read the article, and then there will be a very brief video. So let's go. The November 13, 2022 murders of Haley Goncalves, Madison Morgan, Dana Cornado, and Ethan Chapin, students at the University of Ohio, left the nation stunned and the families of the victims searching for answers. Brian Kohberger, charged in the case, faces 4 counts of first-degree murder and 1 count of burglary. A judge has entered a not guilty plea on his behalf. As attention turns to Kohberger's trial, the murders remain unexplainable with questions lingering. I don't know why it happened, Jasmine Cornado, sister of Zaina Cornado, told 48 Hours correspondent Peter Van Sant in her first interview. I wish we knew. They were, all 4 of them were, just such great people. It made such an impact on the lives around them. Jasmine and her father, Jeffrey Cornado, spoke with Van Sant in The Night of the Idaho Murders, airing Saturday, September 16th at 10 p.m. on CBS and streaming on Paramount Plus. Van Sant asked Jeffrey Cornado about reports that his daughter Zaina fought back against the attacker. I believe so, Pernodal replied, "It's upsetting to think about." Also interviewed were Kaylee Goncalves' parents, Christy and Steve Goncalves, and Kaylee's sister, Olivia Goncalves. "We're not going to just sit back and cross our fingers and pray. We're going to get justice," Steve Goncalves said. That desire led the Goncalves family to undertake their own investigation in addition to speaking with authorities before a gag order was put in place. Steve Goncalves says, according to the coroner, the first victim was Morgan. Both Morgan and Goncalves were sleeping in the same bed in a room on the third floor of the house. After killing Morgan, the assailant then went on to kill Kaylee, Steve Goncalves said. "There's evidence to show that she was awakened and tried to get out of that situation," says Goncalves. "She was assaulted and stabbed." Christy Goncalves explains her daughter had several fatal wounds and that the way the bedroom was set up made it difficult to escape. The bed was up against the wall. The headboard was touching the wall, and the left side of the bed was touching the wall. And we believe that Maddie was on the outside and Kaylee was on the inside, she says. The way the bed was set up, she was trapped. Christy Goncalves believes the assailant was not expecting to find the two best friends together in the same bed. "I do think that his plan went awry. I do think that, he intended to kill one and killed four." Steve and Christy Goncalves said investigators' information also led them to believe that Brian Kohberger may have made scouting trips to the student's house where the murders occurred. He had to know when people were coming, people going, says Steve Goncalves. Christy Goncalves wonders if Kohberger had ever gone inside the home, saying, "I think he at least had opened the door, went in, tested the waters, looked around." The Goncalves also think they may have found a possible connection through Instagram between Brian Kohberger, their daughter, and Maddie Logan. They believe they found Kohberger's Instagram account and he had been following Kaylee and Maddie's Instagrams. From our investigation of the account, it appeared to be the real Brian Kohberger account, says Christy Goncalves. However, Brian Kohberger defense team has stated in court following that there is no connection between Mr. Kohberger and the victims. Investigative reporter Howard Bloom, who has written extensively about the case for Airmail, a digital newsletter, explains in an interview with 48 Hours the prosecution would like everyone to believe that it's an open and shut case, but I think the facts they have made the case perhaps more open than open and shut. Bloom also says if no connection between Kohberger and the victims can be made, can be established, I'm sorry, when there is no more, there is no motive. And if there's no motive, then it becomes very hard to make the case that he is the killer. With the gag order in place, information is restricted, but filings do provide some insight into the defense's case, says CBS News consultant Brianna Fox, a professor of criminology at the University of South Florida and a former FBI special agent. I don't think there's any slam dunk, Fox tells 48 Hours. It seems that the defense is alleging there was a rush to judgment, but I'm sorry, I lost my place. Law enforcement made an arrest too fast and they focused on their client too quickly. The defense filings have tried to poke holes in some of the information alleged in the affidavit released after Kohberger's arrest, such as cell phone data that picked up Kohberger's movements near the victim's house and security cameras that captured his Hyundai Elantra near the murder scene. I'm going to say allegedly, even though it's not there. I just want to say allegedly. They're saying it like the cell phone data, the car. I just want to include the word allegedly. The defense has pointed to concern, says Fox, whether Brian Kohberger's car was accurately identified at the outset or if that identification was affected after authorities learned the model of the car he drove. While the alleged cell phone data makes one suspicious of Kohberger, says Bloom, is not putting someone at someone's doorstep. It's putting someone in someone's neighborhood. And there's a large difference. And if you can convince a jury of this, if you can raise doubts about the validity and the accuracy of the cell phone data, I think you're halfway there to getting the case against Kohberger, either a hung jury or a not guilty with the verdict. Christy Goncalves says, regardless of the defense claims, she remains steadfast in her belief that Brian Kohberger is responsible for the murders and then whenever the trial begins, her family will be there. He's going to feel all of us just staring at the back of his head, says Christy Goncalves. And he knows when he did, and he knows what he did to our daughter. My apologies for that. So I want to play the video. Just 3 minutes. I have to wait for it to load again.
Moscow will forever be known as the scene of one of the most tragic crimes in American history. There's still sort of a darkness whenever you talk to people who will be ever part of the university's history and the town's history.
There are four very, very important names in this case: Kaylee Gonzalez, Madison Mogen, Xana Kernodle, and Ethan Chapin. And if you're going to remember any names from this case, I ask that it be all four. My name is Olivia Gonzalez, and Kaylee was my little sister.
Everybody's going to work, and you look out the window, and there's kids running down the street laughing, and you're just like, how can you be out there playing? My daughter's dead. You know, Kaylee Gonzalez is gone. Stop everything. Everybody in the whole world stop. And everything just keeps going.
My sister, Xana Kernodle, is one of the happiest, funniest people I've ever met. And I had the awesome privilege of growing up with her, and I still have a hard time coming to terms with the facts that it did happen.
Brian Kohberger is accused of stabbing these 4 University of Idaho students in the pre-dawn hours on November 13th, 2022. The murder weapon, which was a knife, has never been found. This is a type of survival knife. Brian Kohberger did not make his own plea. The judge entered a plea for him of not guilty.
Maximum penalties, life in prison, or the death penalty.
Due to the nature of the crimes, the state of Idaho is seeking the death penalty.
He was there to kill.
He came in with a kit. I believe he had a kill kit.
And you believe that everything right down to the implement of destruction, this large marine knife, that was all planned.
All planned.
It's inhumane. You wouldn't do these type of things to any living creature, let alone an innocent human being.
The star piece of evidence in the prosecution's case is the DNA that was found on the knife sheath that was left at the crime scene. But there's so much other evidence that's also pointing towards nobody else that we're aware of. How was Brian Kohberger's car spotted leaving the scene? Why was his cell phone seen there 12 times, including the morning after the offense?
Prosecution would like everyone to believe that it's an open and shut case.
Well, let me just pause it right there. A lot of people were at the scene prior to law enforcement being called. We know that people in the possible fraternity and sororities knew, and they were at the property as early as 8 a.m. The 911 call allegedly did not happen until 11:58 a.m. So the fact that the word had got out amongst this peer group, it would not surprise me if that information traveled, because so many people within the fraternities and sororities, they knew, they called their parents knew. Now, I'm not gonna speak to why allegedly Brian Kohberger was in this area that morning. I don't have evidence of that. There has been no trial. I don't know the area to say what is around there, and I don't know how close allegedly Brian Kohberger was to the house. So I'm not going to speak to that, but I just want to state that there were many people at the murder scene after the murders, but prior to law enforcement being called or 911 being called. So let's, make that clear also.
But I think the facts they have make the case more open than open and shut. According to the defense, there is no connection whatsoever between Brian Kohberger and the victims. And if there is no connection, then there is no motive. And if there is no motive, then it becomes very hard to make the case that he is the killer. And this is a great.
I just want to pause it there. I apologize. I'm not disagreeing with what he's saying. A lot of people want to know the why. They are concerned about the why. They want to feel that there is a connection, that there is something that connects the killer or killers to the suspects. A lot of people cannot understand that evil exists in the heart and in the mind of people. And sometimes when something as tragic and heinous as this happens, nothing nothing is going to demonstrate in any satisfactory why this happened to them. There will never be a reason why this happened to them that will be satisfactory. This is not deserved. Nothing that any of the four victims did in life, in their existence, in their going and coming of the day, through work, through school, through any challenges, any hardships, any arguments, that any of them deserve this violence, this level of hate and anger and rage that happened to them. So, for me, in my opinion, I personally do not need a motive, and I do not need a event or action that connects the killer or killers to the victims, because I know that evil exists. I've seen it in a lot of cases. I've talked about a lot of cases. And again, all of the cases typically have the same things acting in them. The person does not want to get caught. The person is lying in wait. The person has found an opportunity and they take it and they want to get away with it. So for me, I don't need that motive and I don't need that connection. However, I believe that when you're playing to the jury as a prosecutor and you're also seeking the death penalty, those jurors may need a story. They may need details that the average person is going to want to hear the why. They want to be shown the how. They want to understand the why. So they're going to need that story. They're going to want to hear that motive. And they want you to put a story together that rises to the level of an understanding of how this could happen to these four students. Letting them believe and know and demonstrating that evil exists may not be enough in this case, because they're ordinary people for the most part. They're not going to come from a law enforcement, more than likely criminal background, where they don't have any experience with crime scenes, forensics, medical examiner, autopsies, anything. They're not going to have that background. So they're going to need that story and that motive. Okay, so let's keep going. And I'll try to rewind it a little bit. I don't want to over talk.
Star piece of evidence in the prosecution's case is the DNA that was found on the knife sheath that was left at the crime scene. But there's so much other evidence that's also pointing towards nobody else that we're aware of. How was Brian Kohberger's car spotted leaving the scene? Why was his cell?
Okay, I just caught that. She said that was Brian Kohberger's car. How do they know that? This is what's really frustrating. You can have information, and just because you say it and apply it to someone, it does not make it true. Can you place Mr. Kohberger in the car? Do you have a video of him in the car? Do you have his license plates caught? Do you have an eyewitness that can say that was him driving the car? Four-door white car, sedan style. Were the windows tinted? Was there a sunroof? You have to be very careful how you say stuff. You can easily say something as vague as there was a 4-door white sedan. That lets you know you're not being specific about the model. You're not being specific about the year. You're not being specific about the windows. If there's a sunroof, what type of tires, things like that, right? But when you say that that was Brian Kohberger's car, I don't understand how you could say that. There hasn't been a trial. There's been no introducing of that evidence. You can say that it's a car that's similar in style, color, and design. But how many people have a 4-door white car? Look at me raising my hand, right? How many people know someone that has a 4-door white car? My mom. So we have to be careful about, when we make statements. Okay, let's keep going.
I've seen there 12 times, including the morning after the offense.
Prosecution would like everyone to believe that it's an open and shut.
Okay, we have to watch verbiage. She said that he was seen there 12 times. I think she's referring to through investigation and through them looking at the GPS tracking that allegedly that tracking is placing him in this area of 1122 King Road. I don't want to misstate it. However, again, there has not been a trial. We don't know what the evidence is. So we just have to be clear about what we're saying.
Case. But I think the facts they have make the case more open than open and shut. According to the defense, there is no connection whatsoever between Brian Kohberger and the victims. And if there is no connection, then there is no motive. And if there is no motive, then it becomes very hard to make the case that he is the killer. And this is a graduate student, not a trained assassin.
It's more so about putting these pieces together because I know what the puzzle looks like at the end. I have the box in front of me, but I'm missing so many pieces. How did all of these pieces fall to create what I'm living in right now? Where did this come from?
Prepare, feel the force.
Okay, so I just wanted you guys to hear the video portion. We have to be very careful how we say things, what we say, the manner that we say it, the words that we're being used. The intention can be two different things, right? You may want to intend to say something like, you can go back to the car as an example. It has been shown on video surveillance that a 4-door sedan appearing to be light colored, possibly white, was seen on camera near 1122 King Road. Or you can say something like, that was this alleged killer's car on the video. How can you identify that, right? So we just have to be very careful about how we're saying something. And I guess that's where the defense can object and they can go into their reasoning, right? It's dark outside. Is this an eyewitness? Were you able to zoom in on the license plate? You have pictures of the driver. You can do things to refute that testimony. So I just want to be clear that just as, playing that video and having to stop to kind of make statements about what is being said, it's the same thing that's going on in the public about the information relating to the crime scene, the victims. I would hope that there will be a stop to the releasing of factual information because I want this case solved. I want justice for these 4 young adults. They deserve justice. Their family deserves justice. And we don't want to do anything that's going to impede that, stop that, thwart that, make it harder. We're losing time already. And we don't want this to be a cold case. I've looked at so many cold cases that I pass up because I'm not going to bring every single case that happens, right? I want to bring something of value, something that I can add to the forensic, the policing community. So when I'm having these videos, I'm trying to bring education along with them, knowledge, so you can have an understanding of criminal law, criminal procedure, the process of going to court, discovery, collecting evidence, bringing forth witnesses, the responsibilities of the prosecutor, the responsibilities of the defense, and so on. So that's why I'm bringing certain cases and not all cases, okay? So let's hang in there. I am going to watch the one series that starts tonight. I am going to watch it. I don't know what I can gain from it. I'm not going to review it or talk about it on here unless something comes up later that I would have to address, such as what I felt was needed with just the leakage of information involving important facts of the case. So I don't plan on talking about it. So hopefully nothing more comes out. I don't know, because if this is a series or a movie or multiple episodes, more could be released. I hope not. But there's going to be, 2 or 3 more months before trial. So we have some time to wait. So thank you for going along with this journey as always. Thank you for watching this video. I hope you check out some of the other videos. I want you to stay safe, stay smart, stay savvy, protect yourself. Check out the Hidden Horror Facebook page. It has so much information, so many key terms, details, just telling you all about forensics, criminal law, right? So I want you to educate yourself, build yourself strong, so you will be able to talk about these cases, especially if you have an interest. So thank you for this time. This is my second video on this Saturday. I had started really early, so I'll possibly be back. I do have a case that I'm considering. I have to get some information on it, do some research, but we'll see. So thanks for checking out this video. Have a beautiful weekend. Hopefully I'll see you in a future video. Bye, friends. Have a beautiful Saturday afternoon. Take care and be well.